Civilization likes to pretend the legal system is a majestic temple of logic, wise judges, brilliant lawyers, and centuries of carefully crafted rules. In reality, a shocking number of laws exist because someone, somewhere, looked at a perfectly normal situation and thought, you know what this needs? A completely insane lawsuit, which means if you think human stupidity has limits, you're about to be very disappointed because the deeper you go, the worse it gets. 1. The $54 million pants lawsuit. I want you to imagine misplacing a pair of trousers and reacting like a normal human being. Mild irritation, maybe a dramatic sigh. Now delete that image and replace it with a Washington, D.C. judge who decided his missing dry clean pants were worth $54 million. Roy Pearson saw a satisfaction guaranteed sign and interpreted it like it was the Constitution itself. He sued a small immigrant-run dry cleaner for an amount usually reserved for oil spills and small wars. He represented himself. He cross-examined them. He treated missing khakis like a crime against humanity. The case dragged on for years, nearly bankrupting the owners. He lost, spectacularly. But the fallout pushed courts to tighten standards against frivolous lawsuits. In the end, he didn't get new pants. He helped rewrite legal procedure. That's the most expensive laundry day in American history. 2. The man who sued God. In 2007, Nebraska State Senator Ernie Chambers filed a lawsuit against God. Not metaphorically, not symbolically. Literally God. He sought an injunction to stop floods, hurricanes, and general divine chaos. And here's what makes this beautiful. The court didn't dismiss it because it was insane. It dismissed it because God couldn't be properly served papers. No address. No jurisdiction. Procedural issue, which means technically, suing the Almighty is allowed. If you can find his mailing information, the case reinforced rules about service of process and jurisdiction. So, somewhere in the legal archives is a document acknowledging that yes, you may attempt to sue the creator of the universe, but you better have a forwarding address. Divine immunity wasn't the defense. Bad paperwork was. 3. The prisoner who sued himself. Robert Lee Brock, sitting in a Virginia prison cell in 1995, decided personal responsibility was overrated, so he sued himself for $5 million. His logic? By getting drunk and committing crimes, he violated his own civil rights, and since he was incarcerated and broke, the state should pay damages on his behalf. This wasn't a lawsuit. This was a philosophical pretzel. The judge dismissed it, reinforcing limits on standing and misuse of civil rights statutes. Translation: you cannot be both plaintiff and defendant and expect taxpayers to fund your identity crisis. It became a law school classic, a reminder that creativity and competence are not the same thing. It's the only case where even winning would still mean you lose. 4. The Batman lawsuit. In 2008, the mayor of Batman, Turkey, threatened to sue Warner Brothers and Christopher Nolan for using the name Batman in The Dark Knight. He claimed the movies caused psychological harm and increased crime because apparently a fictional billionaire in a cape destabilized municipal order. The legal theory never made it far, but it highlighted international trademark limits around geographic names. You can't just sue a global franchise because you share a word, especially when that word existed long before your modern city did. It became an international punchline, a reminder that publicity stunts sometimes backfire harder than a batarang. 5. The psychic versus NASA. In 1997, a psychic sued NASA for $300 million, claiming the Mars Pathfinder rover trespassed on Mars, where she insisted she was the rightful ambassador. She argued the rover disrupted the planet's spiritual energy, interfering with her psychic communications. NASA was busy landing robots on another planet and had to respond to someone arguing about cosmic vibes. The case was dismissed, reinforcing standing requirements and jurisdictional limits. Courts require you to be from Earth and slightly attached to reality. Apparently, that needed to be clarified. Interplanetary diplomacy remains safe from horoscopes. 6. The Subway for Life meltdown. A man won a Subway for Life contest and then sued because he didn't receive infinite sandwiches until death. Instead, he got gift cards totaling about $13,000. He argued for life should mean eternal hoagie access. The court clarified that lifetime supply means a reasonable approximation, not an immortal meatball pension. The ruling reinforced clearer promotional definitions in advertising law. Imagine thinking a slogan guarantees you cold cuts until your funeral. The sandwich wasn't the problem. Expectations were. 7. The Bud Light Fantasy Lawsuit. A Michigan man sued Anheuser-Busch, claiming Bud Light commercials implied beautiful women would appear when he drank their beer. He drank it. No women appeared. Emotional distress followed. The court dismissed it under the doctrine of puffery, which protects exaggerated advertising claims no reasonable adult should take literally. This case reinforced that commercials are not spell books. If your beverage fails to summon a beach party, that's not fraud. That's reality gently correcting you. 8. The iced coffee ice crisis. A Chicago woman filed a $5 million class action claiming Starbucks put too much ice in iced drinks, meaning customers received less coffee than advertised. The judge dismissed it using the reasonable consumer standard, basically stating that ice displaces liquid, and this is not breaking news. Courts will not protect you from thermodynamics. If you order iced coffee and receive ice, physics is not committing fraud. Newton remains undefeated. 9. The McDonald's hot coffee case. Everyone jokes about this one, but Stella Liebeck's 1992 lawsuit reinforced serious product liability standards. The coffee was served at temperatures capable of causing third-degree burns in seconds, and McDonald's knew about hundreds of prior incidents. The verdict strengthened corporate responsibility for known hazards. The myth became "Lady sues because coffee is hot." The reality was negligence. It didn't create a dumb law. It reinforced a necessary one. And then public relations rewrote the story. 10. The monkey selfie copyright war. When a macaque grabbed photographer David Slater's camera and took a selfie, PETA sued, claiming the monkey owned the copyright. A federal court had to clarify that animals cannot hold copyright under U.S. law. Yes, this required actual judicial time. The ruling reinforced that copyright protection applies to human creators. The monkey got internet fame. The lawyers got billable hours. The law got slightly more specific about species. 11. The shrinking clothes lawsuits. Consumers have sued clothing companies over garments shrinking after washing. Courts had to clarify warranty standards and labeling requirements. We reached a point in civilization where judges had to legally define how much your jeans are allowed to betray you in a dryer. This reinforced disclosure rules and reasonable expectations in consumer goods. Humanity mapped the human genome, but cotton shrinkage still required litigation. 12. The cell phone radiation panic. Multiple lawsuits claimed cell phone companies caused cancer without solid scientific proof. Courts dismissed many under federal preemption and evidentiary standards like Dober. Translation: you cannot sue based on vibes and Google searches. The rulings reinforced that expert testimony must meet scientific reliability standards. Evidence beats anxiety, at least in court. 13. The airline peanut lawsuits. Passengers sued airlines over peanut exposure and allergy risks, prompting clearer disability accommodation standards. While the health concern was real, the litigation forced clarification of what airlines are legally required to control inside a sealed metal tube full of strangers. Policies shifted. Disclosure improved, and the snack cart became slightly more cautious. 14. The video game addiction lawsuits. Parents sued video game companies, claiming addiction ruined their children's lives. Courts largely dismissed these claims, reinforcing First Amendment protections and limits on product liability for entertainment. The rulings clarified that fictional plumbers are not legally responsible for homework neglect. You can't subpoena Mario for truancy. 15. The haunted house disclosure case. In Stambovsky versus Ackley, A New York buyer tried to rescind a home purchase after learning the seller had publicly advertised the house as haunted. The court ruled that since the seller promoted the haunting, she couldn't deny it later. The buyer could back out. The case reshaped real estate disclosure expectations. Property law now includes, essentially, if you market the ghosts, you legally own the ghosts. Casper has precedent. 16. A man once sued Universal Studios after visiting a haunted house attraction because it was, in his words, too scary. I want you to sit with that. He paid money to walk into a building specifically engineered to terrify him, then decided the fear was excessive. That's like ordering hot sauce and filing a complaint when your mouth catches fire. He claimed emotional distress, arguing the attraction crossed the line. The court basically responded with the legal equivalent of, "Sir, it's called a haunted house." The case reinforced the idea that assumption of risk is a real thing. If you voluntarily walk into fake darkness filled with actors holding chainsaws, you cannot later act shocked that someone yelled at you. The law had to gently clarify that advertised fear is not false advertising. It's the product. You bought the nightmare. Enjoy it. 17. In the early 2000s, a woman sued a fast food chain, claiming their drive-through menu board caused her to gain weight because it failed to warn her that eating double cheeseburgers daily might have consequences. I admire the optimism. Imagine looking at a glowing photo of something deep fried and thinking, there is no possible downside here. The lawsuit tried to argue failure to warn about obvious health risks. Courts dismissed it, reinforcing that companies are not required to explain basic nutrition to functioning adults. This wasn't hidden danger. This was cheese, melted, glorious cheese. The legal system had to reaffirm a principle I thought we all learned in kindergarten. If you eat like a raccoon behind a dumpster, the raccoon outcomes are on you. 18. A man sued a casino, claiming the slot machines were deceptively addictive after he lost thousands of dollars, which is fascinating because slot machines have about as much subtlety as a blinking neon sign screaming, "We are taking your money." He argued the flashing lights and near-miss mechanics manipulated his brain. The court acknowledged that yes, gambling is designed to encourage gambling, but also reinforced personal responsibility and regulatory boundaries. You can't sue gravity because you jumped off a roof. Casinos exist to separate optimism from cash. That's the whole business model. Filing a lawsuit afterward is like suing the ocean for being wet. 19. A student once sued his law school because he failed the bar exam and claimed the institution did not adequately prepare him. I cannot overstate the irony. A future lawyer suing over his inability to pass a test about being a lawyer. He argued breach of contract and misrepresentation. The courts dismissed the case, reinforcing educational malpractice limits. Translation: a diploma is not a magic spell. The law had to clarify that attending class does not guarantee competence. If it did, we'd all be fluent in algebra and emotionally stable. Passing the bar requires more than tuition payments and vibes. 20. In a case that feels like performance art, a woman sued a psychic for failing to remove a curse that was supposedly ruining her marriage. She had paid thousands for spiritual cleansing services and demanded damages when her husband still filed for divorce. The court dismissed it because, and I love this, you cannot legally prove the existence of a curse in measurable terms. This reinforced consumer fraud standards and the burden of evidence. Imagine trying to subpoena a hex. Your Honor, the dark energy refuses to appear in court. The legal system had to calmly state that supernatural disappointment is not compensable. 21. A man sued a beer company claiming their non-alcoholic beer still made him intoxicated and caused him to violate probation. He argued the label was misleading. The court examined evidence and reinforced strict labeling standards, but also personal accountability. It turns out drinking multiple bottles of anything that says contains trace alcohol, while on court supervision, is not a brilliant strategy. The lawsuit clarified regulatory compliance thresholds, but more importantly, it proved once again that probation officers do not accept "the vibes got me drunk" as a defense. 22. In a bizarre twist of retail drama, A woman sued Victoria's Secret, claiming a thong caused her injury and emotional distress due to poor design. The court reviewed product liability standards and ultimately dismissed exaggerated claims lacking evidence. Now, I am not here to critique fashion engineering, but when elastic fabric becomes federal litigation, we have officially reached peak civilization. The ruling reinforced that defect claims require proof beyond discomfort. The law gently implied that sometimes the problem is not the garment, it's the decision. 23. A man sued Apple after dropping his iPhone in water, claiming the advertising about durability misled him into believing it was waterproof. The court reviewed warranty language and clarified distinctions between water-resistant and waterproof. Because apparently we needed judges to define the English language, the case reinforced clearer marketing disclosures. If your phone survives a splash, that does not mean it wants to scuba dive. The lawsuit was essentially a $1,000 lesson in reading fine print. 24. In a class action that still makes me blink twice, customers sued a restaurant chain because the mozzarella sticks did not contain enough mozzarella. They argued false advertising due to cheese-to-breading ratio discrepancies. The court examined labeling standards and reasonable expectations. And yes, somewhere in a courtroom, adults debated the structural integrity of fried dairy. The ruling reinforced that minor variations in processed food composition are not federal crimes. Imagine explaining to your ancestors that this is what we fight about now. 25. A man sued a weather service app for failing to accurately predict rain, claiming he suffered financial loss from trusting the forecast. The court dismissed it, reinforcing limits on predictive liability and the inherent uncertainty of meteorology. You cannot litigate clouds. Forecasts are probabilities, not promises. If they were guarantees, umbrellas would come with contracts. The law had to calmly confirm that nature does not sign service-level agreements. 26. A patient sued a hospital after undergoing surgery, claiming the procedure cured his chronic pain and therefore ruined his disability benefits. I need you to absorb that. He was upset about successful medical treatment. The court dismissed the claim, reinforcing that lawful medical care and accurate diagnosis do not constitute harm simply because they affect financial arrangements. It's the only case where someone complained about improvement. Your Honor, I object to feeling better. 27. A woman sued a luxury spa because the silent meditation room was too silent and caused her anxiety. She claimed emotional distress from excessive quiet. The court dismissed it, reinforcing reasonable expectation standards. When you enter a room labeled silent, the absence of noise is not a defect. It's compliance. I imagine the judge sitting there thinking, we have wars, recessions, and this is today's docket. 28. A man attempted to sue a dating app after failing to find a partner, claiming deceptive marketing about successful matches. The court reinforced platform liability limits and clarified that algorithms cannot guarantee romance. Love is not an Amazon Prime shipment. There is no two-day delivery on emotional compatibility. The ruling essentially confirmed that loneliness, while tragic, is not breach of contract. 29. A homeowner sued a furniture company claiming their glass coffee table was too transparent, causing him to walk into it repeatedly. The court dismissed it under obvious hazard doctrine. If you purchase invisible furniture, invisibility is not a manufacturing flaw. The law had to reaffirm that clear glass is in fact clear. Somewhere a judge had to say that sentence out loud. 30. A woman sued a concert venue claiming the music was too loud and damaged her enjoyment. It was a heavy metal show. The court reinforced assumption of risk principles again. If you voluntarily attend an event where the genre is known for amplifiers that could summon thunder, you cannot later claim surprise at volume. That's like diving into a pool and filing a complaint about water contact. 31. And finally, a man sued his ex-wife for stealing his luck after their divorce, claiming his business failed because she took positive energy with her. He demanded financial compensation for lost prosperity. The court dismissed it immediately, reinforcing that metaphysical misfortune is not actionable damage. The legal system, in one quiet moment of dignity, drew a line and said, "We do not adjudicate vibes. If we did, every breakup would require expert testimony from a fortune cookie." And there you have it. Dozens of grown adults walking into courtrooms with the confidence of legal scholars and the logic of a toddler arguing with gravity. Somewhere between suing destiny and litigating disappointment, we've officially proven that paperwork will survive anything. Now I need to know, which one wins the gold medal for absolute nonsense? Drop your vote in the comments, or better yet, tell me the dumbest lawsuit you've ever heard of. And if you enjoy watching civilization argue with itself in public, hit like, subscribe, and buckle up. Because trust me, the madness only gets weirder.